Good morning, and thank you for inviting me to talk about artificial intelligence liability in an IoT world. I'm Phil Kusiak. I'm a Senior Associate at HFW. For those of you who don't know us, we are a sector-focused global law firm. We operate in the aerospace, commodities, construction, energy, insurance and shipping sectors. We have about 600 lawyers with offices, 19 offices across the world. And one of those sectors is the insurance, reinsurance sector. The starting point is, what is artificial intelligence and the Internet of Things? Now the basics are as follows. The term artificial intelligence was first coined by John McCarthy, who was a computer scientist, in relation to a study proposal which sought to consider the question whether learning or any other feature of intelligence can in principle be so precisely described that a machine can be made to simulate it. More recent definitions are tailored more to computer systems themselves, so a branch of computer science dealing with the simulation of intelligent behaviour in computers, or the capability of a machine to imitate intelligent human behaviour. Now there's essentially two categories of artificial intelligence. There's the weak, narrow AI and the strong AI. Most commonly in our day-to-day lives we'll come across the weak AI category, and this is focused on performing one particular task, but a particular task very well. It simulates knowledge and cognitive ability of a human, but in a very particular realm. So examples might be chess or poker programs, spam filters in your email systems, self-driving cars, manufacturing robots that are tailored to do one particular job very well, Apple, Siri and Google Home. On the other side is strong AI. Now, this is very much in the development phase, and there aren't a lot of products that we can point to that are in this space, but basically it's a concept which involves mimicking the human brain. Now this type of AI would have abilities such as self-awareness, consciousness, problem solving, creativity and reasoning. Now there's a few different types of AI that we see and that we may see developed in the future. The first are reactive machines. So this is a form of narrow AI. One example would be IBM's Deep Blue chess program, which beat a Russian chess master in the 1990s. Now this program would be very strong at playing chess, but it wouldn't have the capability to know if you were feeling upset after it beats you. Limited memory is another type, and that deals with some decision-making functions. So in the context of driverless cars, it can make decisions, for example, to change lanes at a particular point in time. Theory of mind is more of a concept rather than a product at this stage, and it essentially is that machines could interact socially with people or with one another. And finally, self-awareness is where machines understand their current state of mind and can use that information to infer what others are feeling and act appropriately. Now the term Internet of Things, IoT, as Forbes set out, the Internet of Things is a giant network of connected things. So this can be various products in the day-to-day environment. It can be your mobile phone connected to your toaster, connected to your kettle, that can all talk on the same system and have breakfast ready for you without you having to really do anything. So essentially it's the interaction of things and people, or things and things, all on a common network. Now before we look at some case examples, I thought I would just set out the basics of liability and contribution at common law. How does liability arise? Now it can arise in the tort of negligence, which is quite a wide concept, and there's a vast amount of case law on this. It can arise under contract. There can be contractual arrangements between parties with implied or expressed terms governing their relationship and who will be responsible for what if things go wrong, and also statute. There's certain statutes that will govern how certain companies or people should act, and there will be certain schemes set up that might impose obligations or liabilities on particular people or companies. Now, I'll just start with negligence, because perhaps this is quite a broad concept and isn't confined to contractual terms between parties. The starting point is the snail in the bottle case. Donoghue and Stevenson is a 1932 decision. In this case, Mrs. Donoghue drank some ginger beer out of a bottle, and there was a rotting snail in the bottle. Now, she fell ill and sued the manufacturer. Now, there was no contract between Ms. Donoghue and the manufacturer, so the court had to look at the relationship between Ms. Donoghue and the manufacturer. And Lord Aitken came up with this quote: "So, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour." So this is the neighbour principle. Who then in law is my neighbour? Well, the answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called in question. So negligence has a few elements that you have to satisfy if you are to hold another party liable. So the first question is there a duty of care? This looks at the relationship between one party and another. There's various cases that deal with how to actually approach this element, and the jury's still out in terms of which test is probably the correct test, although some authorities lead to one more than another. Has there been a breach of duty? Has there been, in other words, a failure to exercise reasonable care? Has the breach caused the loss? This is the causation test, commonly referred to as the but-for test. But for a particular act or omission, would a party have suffered loss? And then lastly, is the loss recoverable? Is it foreseeable to one party? Now, assuming one party can actually establish the tort of negligence, a few other things come at play. Now, one matter is contributory negligence. This looks at whether the party that suffered loss or damage has caused or contributed to their own loss. And the Law Reform Contributory Negligence Act deals with situations and governs circumstances where the court might apportion or reduce a claim by reason of one party's own negligence. And contribution or indemnity. This is commonly between co-defendants or between a defendant and potentially a third party where they're also liable for the same loss. Now, having gone over what AI and IoT is and the basics of liability and contribution, I'd like to take you through a few scenarios where things go wrong, and we'll look at how liability and contribution might apply. So this first scenario is a vanilla scenario of a car accident in our current day and age with no AI or IoT. So if car A fails to stop at a red light and collides with car B, now in this scenario, liability could fall to the owner or driver if they were obviously not looking at the red light. It could fall to the car manufacturer if there's a defect in the braking system, for instance. So it may be that one or both of those will be found liable. Now, if one looks at the types of insurance that might respond to a claim like this, you might have an ordinary car or automotive policy, and you might have a products liability policy for the manufacturer. Now, if one was to input some AI into this scenario, so you have an autonomous car A fails to stop at a red light and collides with car B. Now you'll see that liability could fall to a much greater range of parties in this instance. It could still be the owner or driver. It may be that the owner or driver was operating the car in a manual mode, so the IT system, the AI system rather, is switched off. It may be that the AI system has triggered some warnings to the owner or driver to take control and the driver fails to do so. It could still be the car manufacturer. It may be that the brakes have failed or there's been another mechanical fault. It could be the AI designer, so the designer of the actual software that hasn't designed it in a way that recognises and stops at red lights appropriately. It could be sensing or mapping software providers if things were to go wrong, or a network provider if the network fails and the different components of AI are no longer talking to one another. It may be that the network provider has a liability. And interestingly, it could also be a third-party cyber attacker. Someone might have hacked into the AI system and turned off certain controls, thereby causing the accident. Now, if one looks at the question of what kind of insurance policies would respond to this scenario, well, you've still got car and automotive insurance that could cover owners or drivers. There could be product liability insurance for car manufacturers. There may be PI policies in terms of professional services subject to certain exclusions, and possibly quite a new policy type that's in development would be a technology errors and omissions policy, which seeks to cover failures in certain technology. Now, if we take things one step further and look at a scenario where you have full AI, full IoT, in other words, no human intervention whatsoever. Now, this would likely involve strong AI in the sense that it operates almost like a human being. Now, if an autonomous car A drives through an intersection, but the intersection is actually controlled by artificial intelligence traffic lights, which interact with other cars on the road and then switch their functions accordingly. And then that crashes in, or that car drives through the intersection and crashes into autonomous car B. Now, again, the same list of parties could be potentially liable with the same types of insurance that might respond. However, in this scenario, it may be that the traffic light is actually the piece of equipment or the technology that's failed. This raises a lot of interesting questions in terms of whether autonomous cars should be designed or should foresee that autonomous traffic lights might fail and therefore all the cars should stop in any event. So what this will require is really looking into the technology to determine using data and then interrogating that data, who is at fault, and if it's more than one party, how will the court apportion that fault amongst those different parties. Now, adjusting AI and IoT claims. This is a relatively new area, both in terms of technology and the law as well. In principle, adjusting a claim will still feature the same components in terms of investigation and trying to collect evidence and determine the value of loss and how things went wrong. Some key things that I think will be necessary, not only for loss adjusters but also for lawyers and possibly the courts, is really understanding AI and IoT technology and software. To be able to understand why things went wrong, it'll be necessary to have a fairly strong understanding of the technology behind the incident or the accident. This might require expert advice or expert input to determine how these products work. Secondly, would be collecting and interrogating the data. Now, in a full AI situation, you may not have human witnesses who can give oral evidence about why a particular event happened. So it'll be critical to collect the data at a very early stage and then interrogate that data and understand where within that data the right information, the information that you need to determine where things went wrong is located. One interesting aspect that comes out of data is access to data and preserving access in a catastrophic scenario. Investigating cause. This will be looking at whether one or more device or devices were at fault and is likely to require some expert opinion as well from tech experts. And lastly, would be collecting all contractual documents, which adjusters would ordinarily do, which would set out the roles and responsibilities of different parties, but also manuals and user guides for AI and IoT technology. This would assist adjusters to determine whether someone who is using partially or narrow AI technology, whether they've used it in the right way. If it has limitations, whether those limitations have been taken into account in operating a particular device or equipment. Any questions?